Hello everyone, I'm Tjio. I would like to thank Professor Ryder and Angela once again for inviting me to speak at this event. I put up that small painting of Jesus College behind me for this purpose. These are strange times, we all know, but it may well become the new normal. The silver lining could be that the inequalities that are tied to economic crime could be reduced by pandemic shocks such as COVID-19, according to the Austrian historian Walter Schaedel in his book, The Great Leveler. So there's hope for the future. But in the present, we know that banks and financial institutions often act as intermediaries for others, and their customers may be wrongdoers themselves or persons that are wronged by others. So in recent years, we may have focused more on the former than on the latter. The case that I want to talk about this year is Singularis Holdings and Daiwa Capital Markets Europe, a 2019 decision of the UK Supreme Court. The judgment was released in December 2019 and came too late for last year's conference. There, the Supreme Court thought that it was a case bristling with simplicity, which it was at that level. It was held that a contextual approach was to be taken to corporate attribution, so that the sole shareholder who was also a dominant director's wrong could not be attributed to a company to prevent it claiming against its bank. The bank had failed to prevent the defrauding officer transferring money out of the corporate customer's bank account to his own business operations. In other words, whether there is attribution depends on its context and purpose, and depends on whether the company's responsibility is being apportioned with an agent or with a third party. The difficulty was that the claim brought by the company that the bank sought to set aside for illegality was based on the 25-year-old case of Barclays Bank and Quincy Care. Singularis was the first case that had succeeded on those grounds. That action is based on an implied term in the banker-customer relationship that a bank would observe reasonable care and skill in executing its customer's order. The bank would be liable if it knew that the order was dishonestly given, shutting its eyes to the obvious fact of the dishonesty, or acting recklessly in failing to make such inquiries as an honest and reasonable man would make. The bank did not challenge the finding of Justice Rose at first instance that it had been negligent, or that Quincy Care was wrong, given the burdens it would impose on banks, and it also has to observe its customer's mandate. It only focused on the attribution question. At first instance, Justice Rose had also dismissed the claim based on dishonest assistance by the bank had not been willfully blind in relation to the breaches of fiduciary duty by the director. This shows the fortune in being able to find different pathways to a successful claim, but it raises the following questions. First, was this a 2 or 3 party situation, and does that even matter? This was possibly a 3-party situation, as it involved a corporate customer, and the primary wrong was that of the sole shareholder and controlling director. Yet, in the usual 3-party scenario, the claim is one of dishonest assistance by the bank, and we have seen that that failed as the bank had not been objectively dishonest. It had done all the necessary KYC checks, but failed to question the purpose for which the funds were transferred. So, a higher standard was imposed on the bank because it was held that the point of the Quincy Care duty was to protect Singularis against the misappropriation of funds by an agent of the company. This, though, is a failure to meet expected standards of conduct. But that negligent standard was pegged to the fact that the bank was put on inquiry, which is more about a state of mind based on notice. There is an elision of the two here, which again was fortuitous in a way, as negligence liability then allowed a finding that Singularis had been contributory negligent to the tune of 25% in not monitoring and controlling what its director was doing. It is harder to balance relative fault in three-party analysis, where the focus is on secondary liability and states of mind as opposed to conduct. But we have to make sure that there is consistency, or there would be arbitrage across different causes of action in a similar factual matrix. In today's world, therefore, we are very protective of principals, and we lower their agency costs in monitoring their agents. But this shifts information costs to third-party facilitators. It is believed that they are usually the lowest cost avoider, and notice is used as a tiebreaker, which, as we have seen, can come close to negligence. The inconsistency is on whom the burden of proof lies to show notice or the absence of such. For the former, it is often the case now that the bank will have to show that it was not put in inquiry. But with negligence, it is the case that the customer will have to prove that the bank breached its duty of care by not reaching the reasonable standards expected of it. There will need to be some consistency here, as Lord Philip Sales has suggested in an article in the latest Law Quarterly Review, regardless of whether the claim is made in equity or in law. It is of course true that objective standards lower administrative costs of adjudication, but balancing instruments are needed, as a principal or a customer may desire too much flexibility in its internal arrangements, which third parties simply do not know about, nor can they find out about. So we need some disclosure duties and notice creating situations for bank customers, even if we expect our banks to protect us. There needs to also be ways to apportion losses in order to prevent moral hazard on the part of the customer. It is likely to be relative fault on both sides of the equation when intermediaries create losses. I hope to be able to explore this issue more when we meet next September. In the meantime, stay safe and take care.